Hello there, everybody. Welcome to Baptists and the Court, a review of recent Supreme Court decisions. My name is Brent Leatherwood, and I'm privileged to serve as Chief of Staff here at the Ethics and Religious Liberty Commission of the Southern Baptist Convention. We are so glad that you have taken time out of your busy schedule to join us, and we'll be getting started shortly. Before we begin, here's a brief overview of how we're going to spend our time together today. Our guests have a limited window here, so we're going to hold off on taking questions directly from the audience. However, we plan to cover a wide range of topics with them during our time together. In the meantime, if any questions do come up, please don't hesitate to email us at our email address, info@erlc.com, info@erlc.com. So if anything comes up in the course of our conversation that you would like more information on, please don't hesitate to email us there. So now I'd like to go ahead and introduce our experts for today's event. Let me begin by welcoming Kristen Wagner. She serves as General Counsel with our partners at Alliance Defending Freedom. Her role includes oversight of the U.S. Legal Division and Communications, which include over 100 attorneys and staff who engage in litigation, public advocacy, and legislative support. Since 2014, ADF has represented prevailing parties in 12 U.S. Supreme Court victories, including Masterpiece Cake Shop versus Colorado Civil Rights Commission, which she argued before the U.S. Supreme Court. So, Kristen, thank you for joining us today.
Thank you for having me.
Our next guest is Montse Alvarado. She joined Becket Fund for Religious Liberty in 2009 and was named Vice President and Executive Director in February of 2017. With a background in public policy and campaigns, she has led initiatives at Becket in development, communications, strategy, and operations that have helped secure religious liberty victories against the contraceptive mandate, protect the rights of churches to choose their leaders, and safeguard the free speech of crisis pregnancy centers and religious groups on campus. We are so thankful for our partners at Becket. And Montse, we're grateful that you made time to join us today. Montse, you're on mute.
Oh, I said it's such a treat. Thank you so much.
Hey, it wouldn't be a Zoom conversation without somebody forgetting to turn on the mute button.
That's okay.
Right. All right. And lastly, let me introduce my colleague, Chelsea Sobolik, in our Washington, D.C. office. She serves as the Acting Director of Public Policy with the ERLC in our D.C. office. And previously, she worked on Capitol Hill on pro-life policies, domestic and international religious freedom, adoption, and foster care issues. Chelsea has been published at a number of outlets, including the Wall Street Journal and USA Today. And she is the author of Longing for Motherhood, Holding On to Hope in the Midst of Childlessness. And she's hard at work on a new forthcoming book on women and work. And so I, Brent Leatherwood, get the privilege of serving as your host for today's discussion. And I imagine this is going to be a very informative and very engaging conversation. So ladies, thank y'all for making this opportunity happen. All right. So with that, let's begin today's discussion. And Kristen, I'm coming to you first. So can you lead us off by helping our audience get an overall understanding of the just concluded Supreme Court term? Was this a helpful slate of decisions for those of us who care about fundamental freedoms like religious liberty, human dignity, and free expression? Why or why not?
It absolutely was a helpful term. I think both Becket and ADF share the goals of wanting to ensure religious autonomy for religious organizations, of wanting to protect speech broadly, including for conservative and religious groups and individuals. And I would say also a goal is to undermine and effectively overturn what we refer to as the Smith decision. And that's a decision that says that religious freedom is protected or can be protected when a law is not neutral or generally applicable. And that's a lot of legal mumbo jumbo, but basically Smith makes it harder for people of faith to have their First Amendment rights protected. And we saw gains in all three of those areas this term. I think in terms of thinking about the term overall, which we generally think of as running from September of 2020 to June of 2021, there were nearly 60 cases that the court decided. And an interesting piece about that is that's the least number of cases that the court has decided since the Civil War era. So that in itself was unique. And in addition, I would say there will be some decisions we won't talk about today that I think are noteworthy. For example, there's a decision called Tanzan that the court decided fairly early in the term, which dealt with the Religious Freedom Restoration Act and whether individual government officials can be sued for monetary damages under that act. And that the court said yes, and that's a good thing. That expands religious freedom and protects it. There's a case called Mahoney, which dealt with a public school student's rights to speak off campus. And the court said again that in that circumstance, it was wrong for the government to punish that student. And I think we both organizations believe that's a good decision as well. And of course, we will focus on some other decisions that both ADF and Beckett litigated later. And lastly, I'll just say in terms of thinking about the term overall, one unique aspect of this term as well had to do with the emergency relief that the Supreme Court granted. With COVID-19 going on, it takes a long time to get a case to the US Supreme Court. Sometimes it can take 10 years to get a case all the way there. So there were individuals and organizations that filed applications to the court during this term to say, help us earlier and asking for emergency relief. And there were about 150 of those that came before the court just this term. And there were about 29 or so that the court actually granted relief and decided. I mention that because a significant proportion of those had to do with the rights of people of faith and religious organizations during the COVID pandemic to be able to safely worship and what the restrictions were that the government could place on that. And eventually, it started out with some dissents where we were not able to get the relief we wanted. And eventually those dissents built precedent so that when actually Justice Barrett got on the court, we started to see that tide turn. And those dissents turned into majority decisions, resulting in a decision called Tanzan. And I think Tanzan, which outlines the rules under Smith, at that time, it's a good summary, then led to the Fulton case. And I know Monse is going to want to talk about the Fulton case and what that means for people of faith.
Absolutely. So two quick follow-ups based on some of the things you said. One is just kind of on the mechanics of the court. You mentioned this was a slightly slimmer docket of cases that they took since the Civil War. Do you attribute that to COVID and some of these cases, not being in person? Is that accurate?
There are a wide number of factors that might have played into the court's decision. And one thing I think we learn when you're before the court on a pretty regular basis, it's dangerous to speculate on why they make the decisions they do. I would say some commentators have suggested COVID may have played a role in terms of wanting to have the capacity to give emergency relief. The election, presidential election, they may have been anticipating they would have more election challenges than what they actually had. That can also be something. The threats of court reform may have also played a role in that, but we really don't know. What we do know and can definitively say is that we moved the ball forward in protecting First Amendment rights this term.
Gotcha. And my next follow-up, and I'll use this also as a lead into Monty as well. You gave a great overview of the term. If you go up to 30,000 foot, what would you just say briefly is the state of religious liberty in American jurisprudence? It sounds like it's pretty strong, but I just want to get a sense from you what your thoughts are.
It's difficult. I think we're going to know much more next term in terms of what the court does next. But I would say that we do keep winning, but we're not winning at the pace that we need to or with the breadth we need to. But what we know, if you watch the court, is that even though the court might not move as quick as the average person wants them to move, they move incrementally. And these are all positive moves that we're seeing the court make to protect freedom. So I think one of the challenges is that the government is regulating more and more in areas that touch on fundamental beliefs that all Americans have. It's not so much the minority religious beliefs that are coming into great conflict, but it's actually even the majority religious beliefs. And I think that there's hope in that precedent that was set with regard to protecting the minority religious beliefs is going to now need to be used to protect basically all of the Abrahamic faiths and their beliefs that seem to be perhaps out of, I guess you might say, political power or cultural power in this moment in our history. But we do know that those winds can change, and we trust that they will. So I think the
Gotcha.
protections are there. We've got the foundation. Now we just need to build the house.
Right. Well, thank you for that, Counselor. And, a number of those wins are certainly attributable to the hard work that your team does at ADF, and certainly your team, Monty. So let me just turn to you real quickly with that same question, Monty. What is your sense of the overall state of religious liberty right now in America?
I'm with Kristen. I'm so grateful for the work that all of our organizations do. I would add all of the religious freedom advocates are really, they've got big dockets, not just our two organizations, but, First Liberty. There are a bunch of other groups. Consovoy McCarthy is an individual law firm that we got to watch carefully because we're all doing really important things and we have our battle lines drawn pretty clearly. One of the great decisions that we didn't get to chat about, but I also think signals something really important about what the court is doing was the disclosures of donors case, the AFP case. I think that was a fantastic signal that individual liberty, the chilling effect on assembly, our ability to come together and worship, to register at our parish without fearing that it's our list is going to be revealed to someone, that we're going to be targeted for our religious beliefs when they tie into also our political beliefs, which happens all the time. We're animated by our religious beliefs to do something in the public square, whether that's in business, in education, or in politics. And all of those things are protected by the Supreme Court. So I'm with Kristen. I am super enthusiastic about where the court is going. Gosh, do I wish that this was moving faster? Absolutely. I've been at this for 12 years. You look in the mirror and you're like, 12 years is a long time. But I am hopeful. And I also know that I believe that the victory is won. So we're doing this work in a very different way, knowing that we're trying to lay foundations for what we already know is true, which is that religious freedom is this fundamental right. So fundamental rights, let's talk about Fulton. Fulton was a fantastic 9-0 decision at the Supreme Court. Sharon L. Fulton, just as a reminder, is a wonderful woman of color in Philadelphia that fosters and adopts young children through Catholic Social Services. And she was told that her agency, because it doesn't certify same-sex couples, could not work with the city of Philadelphia. What did the Supreme Court do? The Supreme Court did something pretty remarkable. First, a 9-0 decision means something very special. It's a signal around the country, and I think a signal to the rest of the world as well, that in the United States of America, rights are not a zero-sum game. The right that was created through Obergefell, this right to marriage that we know is invented from the Constitution, isn't necessarily there plainly, and Kristen, you can always chime in on that, is not a First Amendment right, does not supersede free exercise. It does not supersede what we know about the importance and the preeminence of free expression and freedom of religion. So the unanimity is very special because you have both sides of the aisle coming together to send a signal that these conflicts are not going to be tolerated at the Supreme Court. Number two is exceptions. Exceptions. Anytime you have an exception to a rule, Kristen was talking about the neutrality principle in the Smith decision. The Smith decision says, oh, if I have a neutral law, I'm fine. I can go ahead and burden or get rid of your religious exercise. That's not true anymore. Anytime that the government has any kind of exception to a rule, it has to take religious freedom really seriously. Why is that so valuable? Immediately, it's valuable to the Little Sisters of the Poor. It's valuable because we have so many laws that are being used against us right now, where the government is making all kinds of business exceptions, making special protections for their friends. They also have to make those special protections for religious people as well. So the value of exceptions was very much protected in this decision. Intolerance. When we think about the Masterpiece case, that great victory that Kristen won and her team, phenomenal victory for religious freedom, that there is no greater signal of intolerance than getting kicked out of the public square because of your religious beliefs. And there's a lot of great language in this decision that says that intolerance is not, it doesn't get to play in the United States anymore. And I know that both of our teams are looking forward to building that out in the lower courts and protecting more people around the country. Public accommodations, that should be kind of like a signal for all of us who are working in ministry. We're really worried that the Equality Act is going to turn all of our ministries into public accommodations, things that the government can regulate, that it can get its hands into to tell us what we believe or who our leadership can be or who we can serve. And the Supreme Court was very clear about the definition of public accommodations not playing anything in the foster care context, at least. So that's the beginning of a building block that we're going to be able to use in the future. And then the last one is, which is one that I think is really important because we've talked about it for a really long time, this concept of dignitary harm. This idea that what I believe, if it offends you, I have to cancel myself and get rid of it. The Supreme Court made it very clear that dignitary harm was not at play here. These couples could have gone to any of the other 29 other agencies. They could have worked with anyone else to do what they wanted to do. They didn't need to shut down. The government didn't need to shut down Catholic Social Services. And so the religious beliefs that Catholic Social Services was espousing weren't harming anyone. That's a really important point because it's a point that opponents of religious freedom have been trying to drive home for years. And it's one they wanted to win in the courts. And it's one they used in the court of public opinion, in opinion editorials, and they tried to bully people on TV with it. So to me, that's in a bow, the essence of that decision and why it's so good, so delicious.
Absolutely. Absolutely. Well, I mean, it was such a significant win, not only for Becket, but honestly for Christians of all stripes and for folks who care about religious freedom. So Chelsea, let me use this opportunity to turn to you because we're talking about the church and specifically Baptists. You know, we care about adoption and foster care. So why was this case in particular at the top of our watch list at the ERLC? And what do you think it means for our work and the work of churches serving children who are in the foster and adoption system?
Right, you are exactly right. Christians have cared deeply about vulnerable children for hundreds and thousands of years. We are always the ones on the front lines to care for children who need a mom and a dad. Christians are 2 times more likely to adopt, and families recruited through church or religious organizations foster for about 2.5 years longer than average foster parents. Becket, those stats are from Becket, and I think it just hits home the importance of people of faith being involved in caring for our nation and our world's most vulnerable children. There was a recent study from some child welfare groups that saw that about 1.5 seconds around the world, a child was losing a caregiver. And in the United States today, there are over 420,000 children in the United States in our foster care system, and about 1/4 of those children are eligible for adoption. So what the Fulton case did and said is essentially saying that vulnerable children are best served when there's a pluralistic and diverse group of organizations serving them. We need more people involved in serving vulnerable children, not less. So what this means for Christians and for Baptists is that we can continue the good work that we have always done. We can continue being involved in caring for kids. And I think what the court is trying to do, and like Monsi and Kristen said, there is more work that the court needs to do, especially with the Smith decision. And one of the things we're very actively involved in at the ERLC is opposing the Equality Act and the harmful implications of that bill. But what the court, I think, is trying to do right now is carve out a path where we can have a true pluralistic society where, like you said, rights are not opposing that we can all be involved in caring and loving for our nation's most vulnerable.
Well, as Monty said, the Supreme Court is not necessarily known for moving with speed. But, when these decisions come down, they certainly can have an immediate effect. So, I mean, in this case in particular, we've been working with our friends on the ground in Kentucky. The Kentucky Baptists have been at loggerheads with the government in Kentucky over the Sunrise Children's Services. That is a Baptist entity in Kentucky that serves adoptive and foster families. And once this decision came down, Kentucky immediately came back to the table and agreed to contract with them, which is a major win for not just Baptists, but for the children, the vulnerable children who need to be served. And so these cases really can make a difference very quickly, and that's why this is important. Kristen, so coming back to you as we move away from Fulton, one important case that was decided relatively early in the term was Uzabugnum versus Prashewski, and ADF represented the student at the center of this free expression case. As a matter of fact, it kind of tied together a lot of fundamental rights. And a few years ago, Kristen, you had this great quote that I love, and I use it often, about how our fundamental rights, they actually travel together. And so we need to be paying attention on all fronts, not just religious liberty, not just free speech, but all of them, because they all do travel together. So why is this case such an important one for Christians to know about and appreciate, even if they're not in the educational context?
Well, I had the privilege of arguing that case, and it stems from a student named Chike Uzabugnum. And you're one of the very few, Brent, that has ever pronounced that case name correctly. Chike's family comes from Nigeria, and they just have a dynamic story about how they came to Christ. And when Chike came to Christ in college, he wanted to share his faith on his campus, Georgia Gwinnett College. So in 2016, he set out to do that. He went into a common area of the campus outside the library and started to talk with those who wanted to talk with him about his Christianity and what it meant to him. And shortly, 20 minutes in or so, he was approached by an officer of the campus who said, you can't do this. You're violating the policies. It's a long sordid story, but he wasn't stopped just once. He was stopped twice. After that first time, he went to the school, met with them, tried to follow their policies, which included requiring him to get advance permission, essentially like a permit, in order to share his faith on his campus. And they said he had to stand in a speech zone. And there were only 2 speech zones on that entire campus. If you think about the size of a football field, the size of the 2 speech zones would have been equivalent to an 8.5 by 11 piece of paper. That's how small the speech zones were. So those types of policies, they're illegal. They're blatantly unconstitutional. Every student that faces them, every parent who has a student that faces them should challenge those policies. What happened was the second time Chike got permission to speak on campus, he followed the policy. He was approached again. The officers took his ID back to the car, humiliated him in front of all the students that were passing by. And he was told that if he shared his faith again in this way, that he could be disciplined, even suspended or expelled from the university. The strange thing about this is we knew that these policies were unconstitutional, and ADF had sent a letter to the college years in advance, warning them, this is unconstitutional, let us help you change the policy. They declined to do that. So when this thing happened with Chike, he filed a lawsuit against them, and the college actually initially argued that him sharing his faith was akin to fighting words under the Constitution. Fighting words are not protected, what Georgia was trying to say. They then, recognizing eventually the error of their ways, changed the policy to fix the errors that were in it. But by that time, Chike had graduated, and they refused to acknowledge that they had violated his rights or that there was anything wrong with the policy in the first place. So those are the facts. What the court was looking at was, can Chike's case continue? And what we know is that the Constitution says courts shouldn't be deciding cases if there's nothing at stake. There has to be something at stake. So when you hear about injunctions and things like that, that's relief that looks forward, that says we're looking forward to fix this. But the way that we compensate people for what happened in the past is through monetary damages. And we can think of a number of examples, constitutional examples, where monetary damages might not exist. You think about it, if a police officer goes through your home and he doesn't have a warrant, or he pulls you over on the highway and he doesn't have reasonable cause, but he just lets you go. What are the damages there? What's the money that has been lost? It's difficult to prove that. You think about a speaker at graduation who wants to share her faith or reference a scripture verse, and she's denied the right to do that. What's the monetary out-of-pocket damage to her? These constitutional violations do not have easy price tags, and government officials have seized on that to say, we'll fix your policy, but we're not going to pay a price, any penalty. There will be no cost to us moving forward if we fix it moving forward. And so that's what the case was about, was whether the government gets a free pass to essentially violate your rights, and just as they're about to get caught in a legal decision, then say, oh, wait, never mind, we'll change the policy. No harm, no foul. And the court said that's not how it works. In an 8-1 decision, the court said in those situations, if there are not easy price tags, or if for some reason a person of faith or a religious organization doesn't want to sue for a lot of money, they can sue for what's called nominal damages, and the government has to defend that lawsuit and make it right. And so this decision doesn't just help students on campus who often don't have monetary damages, but it helps all kinds of civil rights be able to move those cases forward and establish the precedent that we need to protect rights in the future.
Yeah. And, as you're just going through the facts of the case, I mean, if you stopped before you said, oh, this took place in Georgia, you would think this took place in like a third world dictatorship. I mean, this is just mind-boggling that a case like this even developed. You would have thought at some point somebody said, wait a second, we're really crossing over the lines of the First Amendment here. And so it's just amazing. So I'm really thankful for ADF's work on there, and I'm glad that the court sought to give him relief. So, all right. So this next question is for all of you. And Chelsea, why don't you start us off with this one? So what else caught your eye about the court's posture and decision-making this term? What stuck out to all of y'all as particularly notable from this term?
Absolutely. So I'm going to give my answer, and then I would love Kristen to chime in as well, since she has been working on this case for quite a long time. But one thing to note, this was not a win or a loss. It was the court's refusal to grant cert to the Adriennes Flowers case. And just a brief overview of what this case is. So in 2013, Baronel Stutzman, who's the owner of Adriennes Flowers in Washington, made news for not providing flowers for a same-sex marriage. She had served everyone who came into her shop, and this customer, she routinely served joyfully, gladly, had a wonderful relationship. When he said that he was going to marry his partner, she pulled him aside and said, I will continue to serve you, but I can't do a custom arrangement for your wedding. The customer's partner posted something on social media. It went viral, and she was sued. I think the important thing to note in this case is Baronel Stutzman's conscience would not allow her to create this artistic expression to celebrate something she believed was wrong. In essence, they were trying to compel her speech, which violates her freedom of speech and her religion. So her case has been circulating the courts for a long time, but most recently, the Supreme Court refused to take up cert in this case. So that's a very, very brief overview. It is extremely disheartening to see that they have refused cert on that case. Kristen, I know you've worked with Baronel for quite a long time, so I would also love your reflections on this as well.
Sure. Well, I practiced law for about 16 years at a firm in Seattle, Washington, and this case comes out of Washington State. And it's really the case that I think God used to help me to, what I felt at the time, take the risk, leave my partnership, and come into this work full time. And she's just such an incredible woman. She served this customer for nearly 10 years. And we've been litigating the case for 9 since then. So it was rough, and it's a grave injustice that the court didn't take the case. The court didn't need to rule on the case in order to give Baronel relief. So there were other avenues that were available. I think from my perspective, I see it as a bit of a casualty of what the court did in Fulton. There are so many good things about the Fulton decision, but I would encourage listeners to also read Justice Alito's concurrence in that decision, which highlights all the problems with Smith and why we need to continue to work in this area. And like I said, Montse's highlighted so many good things that come out of Fulton, but we have more work to do in helping the court connect free exercise rights of churches or religious organizations and understanding that it's the people that sit in those religious organizations, it's the people that attend those religious organizations that also deserve that protection. So helping them understand it's not just a right that extends to religious organizations, which we're having to fight tooth and nail over to get, but it also extends to people in the marketplace and in all of our different licensed vocations. And I'll just add this: we had I've never been so happy to lose a case. That was an experience I had this week. I argued in November a case called 303 Creative out of the 10th Circuit. And it involved a website designer who designs custom websites. And she argued that it violated her rights, both free exercise and free speech rights, to be forced to create custom websites for weddings and for other occasions that would violate her core beliefs. We drew a very exceptionally liberal panel, left progressive panel. And except for we had one judge, it's a 3-judge panel, the Chief Judge Timkovich, who we were hopeful would write a strong dissent in our favor. And he did. That came out this week. And the majority decision actually says that the government has the power to compel us to create art and pure speech and to write things that would violate our core convictions. That's an unprecedented decision. And the chief judge actually led with a quote from George Orwell on it, saying, "I never thought I would compare what's happening to, George Orwell's book, but here it is." So we're hopeful that that's going to be the vehicle that the Supreme Court will finally address this issue and end this and help people like Barronelle. And the decision came out the day before Barronelle's petition for rehearing period was up. So it's very rare for the court to accept a petition for rehearing in a case, but we filed one 2 days ago in her case. And so we're hoping that the court will at least hold that petition until it decides what to do with the 303 Creative case.
So for our audience, Kristen talking about 303 Creative, that's a case to certainly be paying attention to. All these cases are that we're talking about, but certainly that one, and we should certainly be thankful for Judge Timkovich's dissent in that case. Monty, let me turn it over to you.
Yeah.
What are your overall reflections and anything else that stood out?
Sure. I think so. There are two things that I think are really important. I'm with you, Kristen, on and Chelsea on the heartbreaking losses. We had a denial as well in a case called Ricks. This is a man who believes that his social security number is the mark of the beast. In Idaho, it's IRS code 666. I don't think that it's something that is made up. There are many ways that the government can decide to identify you. It actually doesn't need you to give it your social security number. It knows it already. So compelling this kind of submission from this person and this acknowledgement of something that he believes is fundamentally wrong and complicit is sad as well. There are real people who lose real cases. In Justice Barrett's confirmation hearing, she talked exactly about that, how the court has to realize that there are real people on the other end that are coming to the court for help, period. I know that we want to change the law and we're working really hard to have strategy, and you hear us talk about these big concepts and these big things in the law, but ultimately this is about people. And it is heartbreaking to see people lose their cases and to see attorneys like my team, like Kristen and her team, pull every stop they can to overturn these injustices. So I think prayer is definitely something that we've got to learn to add to the equation, first and foremost, in trying to understand some of the reasons why these things happen that sometimes don't have legal interpretations. We never will know, except for the 9 people and a couple of others, clerks that help them out, why they decided to do that and what's in the cards going forward. I totally agree. Looking at that concurrence gives you a roadmap. Justice Alito's concurrence, and even the one from Justice Barrett. There's a discussion happening in the court right now that's really important. What happened 30 years ago, and how do we fix it? And how do we bring everyone along with us, as in the justices who don't necessarily believe that something wrong happened? How do we bring as many people along with us so that we don't have this fight again? And so that Congress, which we know is locked together, doesn't mess this up, because they got it right when they tried to fix this with the Religious Freedom Restoration Act. And I'm sure that's a buzzword here. Everyone should know the Religious Freedom Restoration Act, or RFRA. And it's clear that our country wants to protect not just religious minorities, but everyone, and their search for God, not defining that for anyone. That's really important. It has nothing to do with Muslim versus Christian or Jewish or whatever. Even if you don't ascribe, we know that religious individuals in the US don't necessarily ascribe to an institutional or defined religion. That research has been coming out over and over and over again. What does that mean? It doesn't mean people don't believe in God. It just means they don't want to tell you what that means to them. And that's okay. The government shouldn't force you to describe your religion to them. It's not their business. But I think there's something that we've all alluded to that's really important. Religious freedom has really become the cornerstone of how the court is addressing individual liberty. It used to be the canary in the coal mine, the thing that told you that there was something wrong with the law. And now it's at the forefront. It's that crack in the dam that opens up the floodgates to freedom. It's the thing that is going to open up religious freedom on campus for students, and religious speech and freedom of assembly. All of our rights that are rooted in religious freedom are going to open up because of this great decision in Checo's case. The Foundation for Individual Rights and Education has been trying to do this on secular grounds for years. What broke it open? Religious freedom. It's the same thing with COVID. What broke open businesses being allowed to claim that they needed to be able to reopen? Churches reopening. It took the California government telling people that they weren't allowed to have more than 3 family households in their homes. The government coming into your house and telling you how and the conditions in which you could worship. It's crazy. It's communist. This is not Cuba. It took that for the Supreme Court to say, whoa, let's stop. And then for people to be able to leverage those decisions to open up their theaters, to open up their home businesses. It's a big deal. Again, religious freedom is the thing that's that crack in the dam. And it's going to continue to do that. And I have hope for that if we stay strong, if our teams have the support that they need to be able to do the good work that they're doing. And when I say support, I mean prayer. And I also mean people in our communities who have the courage to do what Baronelle did, to spend those 10 years in court, plus if she gets to continue.
Well, you mentioned several times Justice Barrett, and this was Amy Coney Barrett's first term on the court. So I'm just generally interested from all of you. Is the sense that Justice Barrett has made a positive effect, had a positive effect on the church and its decision making?
Well, I think that yes, it certainly has been a positive effect. The significance of that effect long term is yet to be determined. There have been some disappointing moments, to be sure, and we've talked about a couple of those. So I think to see where that goes, as well as in the next term, is important. But I think it's going to be positive overall, and I'm looking forward to see where the court goes, because we've already seen some changes on it. And Monty opened with the Thomas More AFP decision, which has to do with donor disclosure. And that was also an ADF decision. And I think in that case, we can also see the difference that both Justices Barrett and Kavanaugh made, where the state is trying to compel religious organizations to disclose even their donors. So I appreciated the rallying cry that Monty made. And I just want to echo that before we move on from it, because if we don't have courageous clients and religious organizations that are willing to take the heat, then we can't win these cases and we can't protect these freedoms. And we also do know that apart from Christ, we can do nothing. So it's really hard when you get kicked in the teeth, which it very much felt like that's what the Baronelle denial was, knowing she's facing 7 figures in a judgment against her that will likely financially ruin her, to get back up. But what we know is that God has a purpose in these things, and we see him working. And I believe Justice Barrett's a part of that. Justice Kavanaugh, Justice Gorsuch, these are all positive changes.
Absolutely. Okay. All right. Well, let's now get out your respective crystal balls and let's look at what awaits for us in the upcoming term that will begin the first Monday in October. So, Monty, as we did at the beginning with Kristen, I'd like for you to just kind of set the field for our viewers and give them a sense of what to expect this upcoming term. And I'm curious, what are the cases that you and your colleagues at Beckett have circled to be really paying attention to, and why?
Sure. So I think it's more cowbell, you know? If we learned anything from this term, it's that we have more questions than answers. And the court has agreed to address more issues than, and even just to take a look at, more issues than I think we have cases for right now. So definitely closing out what happened this term, looking at the horrible, in my mind, the horrible outcomes of the denials and what the court is going to do with that. So putting that to the side, there are cases on their docket right now that we hope that they will take. I'm assuming God willing, Kristen, that 303 case will get up there fast, So as if you have a trajectory with cases like businesses that want to apply the Fulton decision and build out this ability to live your religious beliefs in the business world, that's number one. Number two is the abortion decision, the Dobbs case out of Mississippi. For the first time ever, my colleagues at the Becket Fund and I actually filed a brief talking about the litany of problems for religious freedom that have come out since the Roe Casey framework was created. It's a big deal, the kind of conflicts that has created, aside from just the fact that it's wrong, that unborn life is real, right? And the way that science has moved, all of those pieces, there's so much there. And I know that you're probably going to do a separate webinar on that. I'm sure you're going to break it down for everyone. But watching that and all of the elements that come with it is really, really important. And then there's also another great case called Carson that the justices decided to hear. Why did they do that? And this is reading a little bit of tea leaves, which as a non-lawyer, I do like to do, even though I shouldn't. It was very clear with the Espinoza decision that everyone was allowed to put Blaine amendments behind them, that the government doesn't get to discriminate against you in the education context. But no one did anything with it because it wasn't clear enough. It wasn't a clear enough signal. And so now the Supreme Court is going back to take a look at this definition of status, the status definition, and telling everyone, okay, if you are religious, if you fall into religious status, hopefully this is what they will do. You are allowed to work with the government to educate your community. You are allowed to have voucher programs, release time programs, charter schools, the whole gamut. And I hope that one, COVID probably showed us that that's really important in the education context. And two, I hope that will ring around the country and that people will wake up and realize that the court can only do so much. It can open a door, but if we don't walk through it, what are we doing? So I'm really hopeful for that. And then the Becket Fund does have another petition that I hope that the court will take coming out of Albany in New York. The state level Reproductive Health Care Act, which is just an abortion mandate, is being challenged by goat raising nuns. We love our nuns at the Becket Fund. And I don't think that there's really a compelling interest to force goat raising nuns to provide sterilization and contraception and abortion. So we're hopeful that will be clarified and that we'll continue to build that out this term.
Yeah, well, when it comes to nuns, I would put the winning streak for nuns up against just about any potential client at the U.S. Supreme Court. So yeah. Kristen, okay, so Monty mentioned the Dobsby Jackson Women's Health Clinic case. So, you and I, we were together last week at a meeting on Capitol Hill, and you mentioned the importance of this case for the future of the pro-life movement. Could you expand on some of the thoughts that you shared in that meeting for our audience?
Sure. I think it's the most important pro-life case in a generation. And again, we don't know what the court will do with that case. So that's leading up to the oral argument. But, the goal is for the court to overturn Casey and Roe. And ADF has been closely collaborating with Mississippi, which is where this law comes from. The law was adopted in 2018, and it's called the Gestational Age Act. And basically what it says is that abortion is limited in Mississippi to 15 weeks, except in the case of medical emergency or severe fetal abnormalities. And those things are defined in the law, what would qualify. So it's not just this blanket exemption. And the reason sometimes we'll get questions of, well, why 15 weeks? Why did you draw the line there? And I think it's important for our listeners to understand that as they're engaging in these discussions. First of all, it's important to know that the United States' abortion laws are the most extreme laws in really the world in many respects. There's only we are one of 7 nations in the world that allow abortions up to 24 weeks of gestation. And 75% of all nations in the world actually stop abortion at 12 weeks. And yet here we are. What has happened with regard to the United States laws is this constitutional right to abortion was manufactured through Roe. It was reaffirmed in a case called Casey. And that has been what the court has followed this entire time. What that essentially means is that states have been unable to regulate abortion prior to a baby's viability. It's life outside the womb. And most people believe that that period is about 22 weeks or so. So these laws that are about 20 weeks or 22 weeks or 24 weeks, they don't tend to get challenged by the abortion industry because it's too close to that viability rule. I'm hoping I'm making sense here, but hopefully we connect the dots on why 15 weeks is so important. Because if we have a ruling that protects life at 15 weeks, we've essentially gutted Roe and Casey. And we can talk about the implications and what that means, but we're very optimistic. And I think one last thing to point out, because a lot of people don't realize that we've learned so much in terms of science since Roe came out. For example, a 10 to 12-week-old baby is capable of and does respond to pain. And from the time of 14 weeks to 20 weeks, we know that it's consciously reacting to pain. And we know that at 15 weeks, the primary abortion that takes place, the means of that is a D&E. And that is an inhumane practice that tears apart a child who knows what pain feels like. It is an inhumane procedure. And that's another reason that the 15 weeks is a good place to start to get the court to essentially gut those bad decisions.
Absolutely. Well, Monty, you mentioned your brief. We also filed an amicus brief along with some other pro-life organizations in this case. We asked the court, please go ahead and overturn Roe and Casey. And look, if you want some really strong legal reading, I would submit to our audience, look up the brief that was submitted by the state of Mississippi.
Fantastic.
Honestly, this case is bringing out some of the sharpest legal minds and legal strategy when it comes to the pro-life movement. So, Chelsea, that is a perfect segue into our pro-life work at the ERLC. So, can you just help our audience, in addition to filing amicus briefs like the one I just mentioned, what else are we doing on the pro-life front as we prepare for a potential post-Roe moment?
Absolutely. I think it's important to note that even in a post-Roe world, that does not mean that every single abortion ceased to exist. States will regulate abortion. So there still will be abortions, which means, even if Roe is overturned, which we are all very hopeful, a reduction in abortions is a good thing, always a very, very good thing. But it will still exist, which means the church will still need to be involved in caring for vulnerable women and in caring for unborn children. One of the things I love to highlight to folks is, I'm in Washington, D.C. I'm working with our coalition partners with Capitol Hill on advancing pro-life pieces of legislation, but every single person listening, every single person can get involved in caring for unborn children at their local level with pregnancy resource centers, being a counselor, driving a vulnerable mom around town. There's hundreds of ways our listeners can get involved in caring for vulnerable women. At the ERLC level, again, we are working with our coalition partners and with Congress to right now it's budget season. So we are looking with our Senate partners to make sure that the Hyde Amendment, for the first time, it was stripped from the House Appropriations budget. That amendment says that federal taxpayer dollars cannot go to fund abortion. So we are asking for that and a few other very important pro-life riders to be put back in the budget. We are also in January 2023, it will be the 50-year anniversary of the Roe decision. So we are in anticipation of that, doing some programming and planning a lot for churches. Also, I think one of the most special programs that we work on here at the ERLC is called our Psalm 139 project. And what that project does is it places ultrasound machines all over the country, and we're looking at a Northern Ireland placement as well. But when women come in and they see their unborn child, they are far more likely to choose life for their baby. So, at every level, we are engaging and encouraging Christians to get involved in this, because it matters. It matters deeply to those vulnerable women and to the unborn children.
Absolutely. Well, and you mentioned that 50-year mark that's coming up with the disastrous Roe v. Wade decision. And look, that's what we do at the ERLC. We try and leverage those cultural moments. I mean, everybody's going to be talking about Roe in that moment, if for some reason it isn't overturned. And we want to leverage that to focus the church in a way to really help our culture, and particularly on this front. All right, so this is our last question. Let's see if we can keep this under about 2 minutes. So Kristen and Motzi, so we are privileged to be able to do some really cool things in our work, whether it's at the ERLC, ADF, or Beckett. Can y'all just provide a little peek behind the curtains of your respective roles? So like specifically, Kristen, what's it like in oral arguments before the 9 justices of the Supreme Court? And Motzi, what's it like developing that robust strategy that y'all have, whether it's filing important legal briefs or anything else that y'all do before the court?
Well, it's just a great privilege. It's if you're an athlete, you know what it feels like to have the adrenaline that's going through you in the big game, and that's what an oral argument often feels like, or at least it should. If you don't have butterflies, no matter how long you do it, you shouldn't be doing it. The justices on the court are the smartest and often the fairest at hearing arguments, and they really do care about the decisions that are made. So in Uzabunum, for example, it was a very technical argument that had to be made, whereas Masterpiece was more of a cultural moment with just a lot of emotional hostility. So arguments can vary in terms of the fears that you might have and the way the justices will ask questions and things. But ultimately, it's much like an athletic competition, except I think you train even more. And I think I would just say, for me, in terms of the role that I have in overseeing the U.S. work, the greatest part of this is seeing Jesus work through the work. It's seeing Christ work through people and having to constantly remind the team and even myself when we have these great ups and then these really low lows. God knows what's going on. He's trustworthy, and I don't know how it's going to end, but he didn't call us to win necessarily. He called us to be faithful, and through that faithfulness, we can win. And I think, as you've heard today, there are many reasons why we think both free speech and religious freedom are on the right track and will be protected.
I'll chime in and say the same thing. I mean, again, I love the more cowbell, so I'm with you there. Absolutely, the ups and downs are covered by grace and by the reality that we're not in control. But my work is with our clients and making sure that people know their stories, and that we remember that there are human beings who are standing up for all of us, and that we remember to thank them and to pray for them, and that the New York Times is fair to their stories and features them in a beautiful way. So I have the privilege of getting to do that work, and I'm so grateful for it and for this team. It is very hard, but building that strategy with a wonderful team, it's good work and it's privileged work.
Absolutely. Well, hey, what an informative conversation. Thank you for that, ladies. And on behalf of all the Christians who are watching and all the folks who care deeply about these fundamental rights, thank you for the incredible work, the incredible gospel-motivated work that each of you do to advance those first freedoms. So for additional information about the indispensable work of the ERLC, please visit our website at erlc.com. And please find more information about the excellent work of our partners, Alliance Defending Freedom. More information about them can be found at adflegal.org and Beckett at beckettlaw.org. So we are just grateful for y'all. And so for everyone here at the ERLC, thank you and have a good day from Nashville, Tennessee.